Good to have you back. This is Environmental Intelligence, episode 29 for April 29th, 2026. Here's what changed overnight in the environmental regulatory landscape. BC courts issued two significant rulings this week on Indigenous rights challenges to major projects, directly affecting regulatory approvals under provincial environmental assessment processes and forestry legislation. A BC gold mining company received a $162,000 penalty for environmental non-compliance, reinforcing EMA enforcement expectations on mine sites. Federal proposals to expand law enforcement powers over small mail packages appear in the 2026 Spring Economic Update, with potential implications for cross-border contaminated sites documentation. Practitioners should review project-specific consultation records and Indigenous engagement files this week for litigation exposure. The BC Supreme Court ruled that Wet'suwet'en Hereditary Chief Dista Hill cannot rely on Indigenous law to overturn his criminal conviction stemming from opposition to the Coastal GasLink pipeline. The decision closes one avenue for challenging provincial approvals issued under the Environmental Management Act and associated permitting regimes. Previously, courts had accepted some Indigenous legal arguments in title cases. This ruling narrows that scope for future injunction or contempt proceedings tied to linear projects. For consultants and counsel supporting pipeline, mining, or transmission projects, the decision increases regulatory certainty on existing approvals. At the same time, it elevates the importance of early, documented Crown consultation records that can withstand judicial review. Watch for appeals or parallel civil claims that could still delay construction timelines. Next steps include updating risk registers for any active projects in Wet'suwet'en territory to reflect narrowed defense options and enforcement actions. What I find notable here is how this ruling sharpens the evidentiary burden on consultation files well before any enforcement action is even contemplated. In practice, that means your Phase 1 and Phase 2 deliverables for linear infrastructure in northern British Columbia need to treat the consultation record with the same rigor you apply to contaminant delineation. A BC gold mining operation was fined $162,000 for multiple environmental compliance failures under the Environmental Management Act. The penalty underscores Ministry of Environment and Climate Change strategy expectations for timely spill response, effluent monitoring, and permit adherence at hard rock mine sites. Operators and their consultants should immediately audit current EMA permits against recent inspection trends. The goal is to avoid similar administrative penalties that now routinely exceed six figures. The Carney government included legislative changes in the 2026 Spring Economic Update that would expand law enforcement authority to search and seize small mail packages without prior judicial authorization in certain circumstances. While framed as a public safety measure, the amendment has downstream implications for environmental consultants shipping soil, water, or waste samples across provincial or international borders. Laboratories and remediation firms should review chain of custody and manifest procedures. The review needs to ensure compliance with any new search and seizure protocols that could compromise sample integrity or trigger reporting obligations. A BC First Nation has filed suit against the provincial government for approving logging within a designated conservation area. The claim alleges failures in consultation and environmental assessment processes. It engages provincial forestry legislation and conservation area designations with potential to set precedent on cumulative effects analysis. Proponents and consultants supporting forestry or land use applications should examine current tenure applications for similar procedural vulnerabilities before submission. Approximately 25% of applied sunscreen washes off during recreational water activities. That contributes an estimated 5,000 tons of chemical load annually to reef areas alone. Many constituent UV filters exhibit toxicity to corals at low micrograms per liter concentrations. The finding is relevant to Canadian practitioners assessing coastal or freshwater recreational sites under the Fisheries Act or provincial water quality guidelines. The data support tighter source control considerations and expanded analyte lists during risk assessments near high-use swimming or diving locations. Concerns are escalating over potential transboundary water pollution in the Minnesota-Ontario border region as the Biden-era mining ban faces reversal. The area overlaps with sensitive watersheds regulated under both Canadian and U.S. frameworks, including Ontario's Lakes and Rivers Improvement Act and Federal Fisheries Act prohibitions on deleterious substances. Practitioners supporting cross-border baseline studies or cumulative effects assessments should accelerate collection of pre-disturbance water chemistry and sediment data. The goal is to establish defensible benchmarks before any policy shift materializes. Petitioners are asking the BC court to set aside approval of a $12 billion natural gas pipeline, citing deficiencies in the environmental assessment and consultation record. The case will test the robustness of current regulatory filings under the Provincial Environmental Assessment Act. Consultants preparing similar applications should prioritize contemporaneous documentation of mitigation commitments and adaptive management plans. That documentation must be built to withstand judicial scrutiny. Environmental journalists are combining satellite imagery with machine learning algorithms to map illegal mining operations across the Amazon. They are achieving improved detection of small-scale artisanal sites. The approach has direct transferability to Canadian monitoring of unauthorized placer or aggregate operations under provincial mining legislation and Federal Impact Assessment Act trigger thresholds. Labs and consultants should evaluate integration of high-resolution, multispectral data into compliance monitoring programs where ground access is limited. Now, speaking of linear infrastructure, there is a nuance in groundwater-surface water interaction that I wish someone had drilled into me early in my career. You arrive at a proposed pipeline right-of-way where groundwater monitoring wells show benzene detections above BCCSR, Schedule 4 standards only during spring freshet. Adjacent surface water remains below CCME guidelines. The discrepancy is not sampling error, but classic gaining and losing stream dynamics amplified by seasonal hydraulic gradients. Under BCCSR Protocol 8 and Federal Fisheries Act Section 36, practitioners must characterize these interfaces with nested piezometers, continuous level loggers, and seepage meters. Static water quality snapshots simply will not suffice. Experienced teams install drive point samplers directly in the hyperhaic zone and apply radon 222 or temperature profiling to quantify flux rates before submitting risk assessments. The nuance regulators rarely state explicitly is that a non-detect in the creek does not negate a requirement to demonstrate no measurable deleterious effect when groundwater discharge occurs. The most common mistake is treating surface water and groundwater as separate silos in the conceptual site model. That approach leads to approval delays or unexpected adaptive management orders. The fix is to build a coupled groundwater surface water model calibrated to seasonal data at the earliest Phase 2 stage. Present flux-weighted loading calculations in every regulatory submission. If you are working on projects in Wet'suwet'en or overlapping territory, review all active files for consultation record completeness following the BC Court ruling on Indigenous law defenses. Audit current EMA permits at mine sites against recent penalty precedents to confirm spill response and monitoring protocols meet ministry expectations. Update chain of custody and sample shipping standard operating procedures to address potential new federal small mail search authorities before next quarter's laboratory shipments. Accelerate baseline surface water and sediment sampling programs in the Minnesota-Ontario border region where mining ban reversal is anticipated. Incorporate multispectral satellite analysis into proposals for remote site compliance monitoring to strengthen detection of unauthorized activities. Mark your calendar for May 5th, when the Federal Spring Economic Update details containing mail search legislative language are anticipated. Brief project teams on documentation implications. May 12th brings the BC Supreme Court hearing window for the $12 billion natural gas pipeline judicial review application. May 15th is the Ontario Ministry of the Environment, Conservation and Parks expected window for updated guidance on transboundary watershed monitoring. May 30th is the CCME Intergovernmental Working Group meeting on water quality guidelines where boundary waters issues may be raised. Before we wrap, watch for further details on the Federal Spring Economic Update and how the mail search provisions could affect laboratory courier contracts. That's environmental intelligence for today. If this briefing is useful to your practice, share it with a colleague and subscribe wherever you get your podcasts. We're back tomorrow. Have a productive day. This podcast is curated by Patrick, but generated using AI voice synthesis of my voice using ElevenLabs. The primary reason to do this is I unfortunately don't have the time to be consistent with generating all the content and wanted to focus on creating consistent and regular episodes for all the themes that I enjoy and I hope others do as well.